The recent case of Idexx Laboratoires Italia concerns the right of a trader to deduct input tax. I'm not sure if you can hear the double X in my pronunciation of its name, or how they expect you to say that. Specifically, it's about the conditions that a member state may impose on a trader who wants to deduct the tax. The right to deduct is given by Article 167 of the Principal VAT Directive. It's very short and simple. A right of deduction shall arise at the time the deductible tax becomes chargeable. It's based on a fundamental principle of VAT, that VAT should not be a cost to any of the links in the supply chain until it reaches the final consumer. If every supplier, every taxable person, charges VAT on outputs but also deducts VAT on all costs, the system will collect the exact proportion of the amount paid by the final consumer. If a taxable person in the supply chain suffers non-deductible VAT, then the system will collect too much. There'll be more than the VAT fraction in what the consumer pays. The right of deduction is therefore a directly effective right given to taxable persons by the directive, and the Court of Justice has consistently enforced it over the years in a string of cases brought by the Commission and by taxpayers. These historic cases are summarised in Chapter 8.2 of the Domestic Manual, and they're worth a look. Look at French Republic, BP Supergas, Gabel Frisa and so on. National rules can't override the right to deduct by simply providing that input tax is not deductible in certain circumstances, as the Greek law did in BP Supergas. They can't impose restrictions on it, as the French law tried to in the French Republic case. Input tax on the construction of a building was capped where the annual rental income from the building was less than 1/15 of the value. The Court of Justice held that there was no authority in the directive for such a provision, and a landlord who had opted to tax rent was entitled to an immediate and full deduction of input tax. Gabel Frisa concerned a Spanish law under which entrepreneurs and professionals could deduct input tax incurred before their business activities commenced. However, this was only permitted if they submitted a formal declaration and began regular business activities within 1 year of its submission. If those requirements weren't met, repayment of input tax was withheld and could be forfeited altogether. The Court of Justice held that the directive precluded national legislation which made the right to deduct conditional on making a formal request before the tax became due, and also on meeting a time limit of 1 year from the date of the request. A person preparing to trade is engaged in economic activity and is entitled to a deduction. National law can't impose conditions that are overly restrictive or overly hard to comply with. On the other hand, Article 178 of the Principal VAT Directive states that in order to exercise the right of deduction, a taxable person must hold an invoice in respect of the supply of goods or services, and that invoice must be drawn up in accordance with Articles 220 to 236 and Articles 238, 239 and 240, and in general, the trader must comply with the formalities as laid down by each member state. Member states have the right to impose conditions on traders to prevent evasion, avoidance and abuse. There are several cases in Chapter 9.3 of the Domestic Manual to illustrate this rule. For example, in Jorion, the Court of Justice held that Belgium was entitled to specify the required content of VAT invoices, and if those invoices didn't have all those details, the trader wasn't entitled to deduct the tax shown. In Reisdorf, the German authorities were entitled to insist on original invoices, not copies. Which brings us to the point of the Idexx case. How do you balance those two rules? There's a right to deduct, but you have to hold an invoice. Are the authorities entitled to be picky about the paperwork? Surprisingly, well, perhaps I shouldn't be surprised, but I am, the Court of Justice takes a common sense view rather than a particularly legalistic one. The point of the paperwork is to prove the facts. If everyone is agreed about the facts, and there's no dispute about them, then a problem with the paperwork on its own shouldn't deny the trader the benefit of a favourable treatment that the agreed facts would justify. That's refreshingly sensible and generous. This was first emphasised in the case of Collet, which was about the formal record-keeping requirements in relation to exempting an intra-community dispatch. The facts weren't in dispute, but the trader had failed to record the transactions in the right place at the right time. Indeed, there was some irregularity about that. I recall that the trader had deliberately manipulated the records for some reason that was unconnected with VAT fraud. The Court of Justice has often held that the risk of missing trader fraud on intra-community transactions justifies stringent requirements for the paperwork. But the paperwork is still there to establish the facts, not the other way round. Here the facts were agreed, and the problem with the paperwork didn't indicate that there was any VAT irregularity. The trader was entitled to the relief. The Idexx case is about acquisitions rather than dispatches, but it is in the same area. Italian law required a person making an acquisition from another member state to record the purchase invoice in 2 different registers. The trader failed to do so and was penalised in the amount of 100% of the VAT, effectively denying the right to deduct. So the Court of Justice has to consider which rules are substantive, as they say, and which are mere formalities. In the case, the substantive requirements for deduction of the VAT are given in Article 17 of the 6th Directive, now Article 168 of the Principal VAT Directive. A string of precedent cases shows that the neutrality of the tax requires deduction to be allowed where the substantive requirements are satisfied, even if there are breaches of some of the formal requirements. The substantive requirements are that the acquisitions must have been effected by a taxable person, that that person must also be liable for the VAT payable on the acquisitions, and that the goods in question must be used for the purposes of the taxable transactions. The Italian legal obligations for paperwork were imposed under Articles 18 and 22 of the 6th Directive, now in Article 178 and the accounting sections of the Principal VAT Directive. Precedent showed that such requirements shouldn't exceed what is strictly necessary for the purposes of verifying the correct application of the reverse charge procedure or to prevent fraud, and mustn't undermine the neutrality of VAT. In this case, it appears that those requirements exceeded what was strictly necessary, so the appellant should not be penalised. Another victory for common sense.